Okay, just see how many people. Okay, I'm not sure quite how many people are on at the moment. I'm having difficulty seeing, so I'm assuming there is an audience. Welcome to this. This is the third joint BVI Finance and RISA webinar series. This one is focusing on debtor-focused issues, which I think is quite a topical subject. Some housekeeping rules. For those of you that don't know, RISA is the insolvency and restructuring industry in the British Virgin Islands, formed to promote and support the development of insolvency and restructuring industry in the BVI. As you well know, some of you, it has regular social events throughout the year, as well as obviously these more pertinent educational and professional development events. I have the easy job today of moderating this distinguished panel, and Russell Crumpler. The way we're going to do it is I'll briefly introduce the panelists in a minute. And the structure you'll see on the screen, I hope everyone can see that, is just the general framework we will follow over the next hour. What does insolvency mean? What should I do if signs of financial difficulty or distress start arising in relation to a company? Who's liable to the debts of an insolvent company? What should I do, most importantly, if my company goes into insolvency? And of course, the necessary subjects that revolve around that. Does insolvency necessarily mean terminal? And of course, what does it all mean for me? Or perhaps more importantly, what does it all mean for my client? As I said a few minutes ago, I think this is a particularly pertinent subject at the moment. We are all very well aware of the global issues that are going on. The BVI is very much part of a global network, and more often than not, BVI companies are part of global groups, parent companies or holding companies and the like. So what goes on around the world has repercussions very much within the territory for us all. We can't ignore the fact that there is a great deal of press coverage around the British Virgin Islands at the moment. A respectful nod to this being the third webinar in this series, the Paradise Papers being the third papers in a series of papers beginning with P. There is obviously COVID, inflation, that all has dire effects on companies. Government support for those companies during COVID is slowly being withdrawn. We all know from the UK point of view that insolvencies are on the rise. Will that have a knock-on effect in the offshore jurisdictions? And I think the more realistic of us know that there may be some difficult financial times for BVI companies coming ahead. So it's important that insurance is kept up to date, that the people who are running the companies, officers, legal advisors, corporate services are alive to the issues that are coming and can avoid them, avert them, and deal with them when they eventually rise. With that in mind, it falls to me to introduce the panel. As I said, we have Russell Crumpler of KPMG, a well-seasoned insolvency practitioner within the jurisdiction. Mungo Lowe of Forbes Hair, an equally well-seasoned litigator, has been practicing longer than I have. And Anna Silva, who, as well as being an insolvency practitioner herself, also manages corporate services and directorships through FFP. Not to advertise one firm, Russell's with KPMG and Mungo's with Forbes Hair. And with that in mind, I think we will move swiftly on. Our first speaker is Mungo, with the great task of what does insolvency mean?
Thank you very much, Andrew. So what is meant by insolvency? Well, this encapsulates a number of questions. There's the immediate question of when will a company be insolvent? But before we address that, I think the key thing is to understand that once a company is insolvent, it triggers a series of events by which normal rules are disapplied, and a statutory scheme comes down by which a liquidator is appointed for the purpose of taking control of the company's assets, realizing those assets, and then distributing them in accordance with the statutory scheme. And that will very much alter the regular state of affairs with regards to creditor rights, member rights, directors' rights, not just rights, but duties and obligations as well. So when will a company be insolvent? Well, broadly, there are three circumstances set out in the Insolvency Act. The first of which is failure to comply with a statutory demand that has not been set aside. What is a statutory demand? It's a formal demand for payment of a debt more than $2,000, which must comply with the form set out in the legislation. So it must be in writing, must specify the nature of the debt, it must be dated and signed by the particular creditor or the creditor's legal representative. It must require the company to pay the debt or secure or compound for the debt to the reasonable satisfaction of the creditor within 21 days. Now, if a statutory demand is not satisfied within 21 days of service on the company, the creditor can then apply to appoint a liquidator. And on that application, the question of insolvency has been determined. The company will be deemed to be insolvent because it hasn't complied with that statutory demand. So it is very important that it is a way of an important mechanism for shortcutting the process of appointing a liquidator, because it takes out of the equation the issue of whether or not the company is insolvent on the hearing of that application. Now, the company does have a right to set aside that statutory demand, and it must do so within 14 days. And crucially, if those 14 days have expired, that there is no retrospective, there's no mechanism for retrospectively granting extension of time for doing that, although the same arguments could be deployed on the hearing of the application to appoint liquidators. The second circumstance defined in the Act is where the value of the company's liabilities exceeds its assets. And this is referred to as balance sheet insolvency. And a company will be balance sheet insolvent where its total assets are worth less than its present, future, contingent, and prospective liabilities. So the balance sheet insolvency test is superficially straightforward. It's a question of just balancing the liabilities against the company's assets. But in reality, it can present some quite tricky questions when conducting this exercise, especially when one is taking into account future liabilities, contingent liabilities, prospective liabilities. So, for example, the company might be involved in litigation, or there might be a strong prospect of the company being involved in litigation by which it's sued for an unascertained amount. And it's very difficult to take that sort of factor into consideration when ascribing a value to the liability. So the takeaway from the balance sheet insolvency test is, whilst it's very straightforward in principle, it can be a lot harder to ascertain in practice. Cash flow insolvency, that is where the company is unable to pay its debts as they fall due. The test includes debts falling due in the reasonably near future, even if those debts have not actually fallen due at the time one is conducting the test, which obviously means that insolvency could be triggered earlier in some cases than might be expected, and that is something to watch out for. So as I said, the takeaway when conducting both the balance sheet insolvency and cash flow insolvency tests is that the principles are relatively straightforward, but in practice, they can present some difficult issues.
Okay, fantastic, thanks. I think what that really then leads us on to is what should one do if suddenly someone notices signs of financial difficulty with their business and indeed a client company? I think move on to Russell. I think if Russell's got any examples of when this would kick in.
Well, thank you, Andrew, and good morning, everyone. If we're talking about signs of distress, we need to split those almost into, if you're involved in the day-to-day operation of a company versus being a corporate service provider, or indeed being a BVI-based director of a company. And so I'll tackle that first one. You're involved in day-to-day operations, or you have a lot of insight into those operations. And really it's things like calls from creditors, letters being received regarding non-payment of accounts being placed on hold, payments bouncing. And it can literally come down to a feeling of tension amongst management teams with regards to the finance function, etc. And depending on the role that you have within that company, you may see these things from the fringes, or you may be seeing them directly because you're on the face of receiving those letters. Now, in a BVI perspective, one can take that further in terms of things like the non-payment of fees, a company being struck off the register because someone's forgotten to make that payment, and even in more extreme case, the resignation of an RA. These are all the sorts of signs that within a structure that involves BVI companies, there is distress, and people are taking their eye off of those basic duties, those basic functions and necessary steps for a BVI entity, because they're focusing on that distress overall. And so one can talk about all sorts of other signs of operational distress, wear and tear of assets, lack of maintenance, reduction in workforce. But we often don't see those in a BVI environment. Where it gets very tricky then is where you are a BVI director. And even if and I appreciate some of us will touch on the director's duties seminar that is also being held as part of this series. But as a BVI director, even if you've been just put in place to deal with economic substance or to tick another local box, you're the one that knows the local laws, or should know the local laws, and therefore you need to make sure you're keeping aware of these sorts of issues and keeping a very close eye open for these sorts of signs. It's slightly different if you are a corporate service provider and providing a service to a BVI company, and then you should be looking out for different things, and Anna is better placed to give a very high level overview of that.
Thank you, Russell. Good morning, everybody. So yeah, Russell's addressed the situation where if you're working actively in the business that's seeing the signs of distress, but things can be quite different. If you're a corporate service provider in the British Virgin Islands, you're somewhat removed from the action, and it's harder to tell in those situations. So you just need to be very wary. The key things you can look out for, and also importantly for corporate service providers, educating staff as well. So for example, you might receive documentation in the post, or you might be served with documentation for a company that you're acting as a registered agent for. It's important to review those documents and assess if that's causing an issue for the client, rather just, for example, forwarding them on. If you've been served with legal papers, that's a key flag that there's something perhaps going wrong. Also, the importance of understanding what the company does, so you have a feel for what your client's norm should be, and then identify if there's activity that is outside of that normal range. You might receive deteriorating financial information. So Russell alluded to operational issues within the business. We might be a shareholder of that active company that's doing the operations and producing the income that would normally flow up to the shareholder in the BVI. Sometimes distress would mean that there's a stop to that flow of income up to a shareholder. You may be able to request financial information from your subsidiary if you have concerns about the lack of that financial flow, and the accounts of that subsidiary may indicate that the financial position is deteriorating. Other factors that you might see if you're a director, for example, of a BVI holding company, you might be asked to sign resolutions about things that are happening in the subsidiary company. For example, changing of debt to equity might indicate the company doesn't have the cash to service debt. They're asking to restructure within the group. That would be indicative of cash flow problems and a lack of ability to pay up returns on debt. And even going back to dividends, a lack of payment of dividends that used to be paid. If that slows down or stops, it's indicative of maybe a change in the activity. So they're sorts of things that you might come across or that you might see when you're acting for a client. I think the overall message is to be vigilant and to watch out for changes within the activity of the client.
And Anna, I might just share some observations from an insolvency practitioner's view that when we see companies that then where we're appointed as liquidators and the company has gone into a process, or indeed when we're maybe even sniffing around a potential role, you'll see two distinct types of corporate service providers, and I include local directors in this to a degree. One where you're appointed and that is a complete surprise to that corporate service provider, even though they've been receiving all these stat demands and passing them on, and one where it's no surprise at all because they are keeping a proper and active eye on the companies that they support. And I think we would all articulate on this call that the latter is the best way to go. And in an environment that we are in now, as Andrew has alluded to, the world financially may well be going to a degree of pieces going forward. I think it's incumbent upon the CSPs and local directors to be making sure they're informed about what's going on with their clients. Whether that's news feeds, automatic alerts, etc. Forewarned is forearmed, and that would be almost one of my key takeaway messages for the CSPs on this call.
I completely agree with that, Russell. Thank you. And it's critical for corporate service providers here to understand what their clients are doing and the protecting the future of our businesses here. If you don't understand that a company is in financial distress and you're incurring fees dealing with their requests, you might have some accounts receivable due to be paid. We're coming up towards annual government fee time at the moment for second half companies. You certainly wouldn't be wanting to incur costs dealing with these companies if they're likely to go into insolvency in the future. So lack of engagement from clients is a key factor that would indicate there's a problem. You might be in a situation where the BVI company is feeling neglected. For example, invoices are not being paid on time. There's a delay to payments to the registry, perhaps companies going into penalty, or even as we approach another economic substance filing deadline, are you struggling to get information off the underlying companies about the activity, particularly where the BVI company is a holding company and you need information from the subsidiaries? Is this sort of lack of attention being paid to the BVI entity indicative of a wider problem? And certainly registered agents want to protect their active and paying clients and give resources to those clients that will be paying their bills at the end of the year. So certainly being aware of issues in the client book is protection of our own business, as well as mitigating against other risks like regulatory breaches or compliance breaches.
Excellent. Yeah, I completely agree. At the risk of repeating matters, it just comes back to global economy and the BVI's part in it in a well-structured chain. The next one is, who would be liable for the debts of an insolvent company? I think we go back to Mungo.
Thanks, Andrew. This is a pretty broad subject, so I will endeavour to cover it as best I can. It's obviously a fundamental principle of BVI company law, based on English company law and modern commerce, that a company is a separate and distinct entity from its shareholders and directors. So the general rule is that directors are not liable for the company's debts, but may be liable to contribute to the pool of assets, depending on particular actions that they might have historically taken. Members are only liable for unpaid capital in accordance with the general rule. However, I think one needs to bear in mind that once a liquidator is appointed, that liquidator is under statutory duty to take possession, protect, and realise the assets of the company, distribute those assets or the proceeds of realisation of assets in accordance with the statutory waterfall. And as part of that process, the liquidator will necessarily be investigating what potential claims there might be against various other parties in order to swell that pool of assets. In an insolvency situation, the pool of assets available is going to be less than the total liabilities, absent of some extraordinary cases. So the liquidator is going to be doing his best to investigate, and is under a duty to do this, to investigate potential claims. And so the general principle, as I've just outlined, will not be applied, therefore, without exception. And there are a number of mechanisms by which a director or a member or other third parties might end up being liable to contribute to the assets of the company. The first category of situations of claims are what are collectively referred to as clawback claims. This is an Americanism which I think first infected the offshore world via the Cayman Islands and now has spread out to the other offshore jurisdictions. But essentially a clawback claim refers in the BVI context to an unfair preference claim, a claim seeking to recover an undervalued transaction, avoidable floating charge or extortionate credit transactions. And I'll focus on unfair preferences and undervalued transactions. In both of those types of claim, that there are key features. Namely, well, the first point is that these sorts of claims provide a liquidator with the option of going after both sides of the transaction. So on the one hand, they could go after the directors who authorised the particular transaction. That's on the company side. And then they may also seek to go after the party who entered into the transaction with the company. And these sorts of transactions are entered into during what's called the vulnerability period. And this is a time period which will depend on whether or not the transaction was entered into with a connected party or an unconnected party. And whether or not a party is a connected or an unconnected party is defined in the Insolvency Act. Essentially, a connected party is a party that has a close connection with the company. So we're talking about a person who might be a director of the company and also a director of the party that entered into the transaction with the company. So where the transaction is with a connected party, the vulnerability period is 2 years, looking back from the onset of insolvency, which will be the date the application to appoint liquidators was filed. And where it's with an unconnected party, the look back period is 6 months. And a further common feature is that the transaction must have been what's defined as an insolvency transaction, which means that it was either entered into at a time when the company is insolvent, or it causes the company to become insolvent. Now, with regards to unfair preferences, there are 5 points of note. Firstly, the transaction has to be an insolvency transaction. Secondly, it has to have been entered into within the vulnerability period. Thirdly, and this is key, the transaction has the effect of putting the creditor in a better position than it would have been if the transaction had not been entered into. Now, there is a defense available where the transaction took place within the ordinary business of the company. However, it will be presumed if the transaction is with a connected party, there will be a presumption that it was an insolvency transaction and it did not take place in the ordinary course of business. And that presumption, of course, can be rebutted, but it means that the burden is on the party being sued by the liquidator to prove that the transaction took place within the ordinary course of business. Now, with regards to an undervalued transaction, the first key feature is the fact that the company makes a gift or enters into a transaction on terms that provide that the company will not receive any consideration in money or money's worth, or the consideration that the company receives is significantly less than the value of the consideration it provided. Secondly, the transaction has to be an insolvency transaction. So that means that it was either entered into at a time when the company is insolvent or it caused the company to become insolvent. Thirdly, it's entered within the relevant vulnerability period. So 2 years with a connected party, 6 months with an unconnected party. And the statutory defense to an undervalue transaction is that the company entered into the transaction in good faith and for the purpose of its business. And at the time of the transaction, there were good grounds for believing that it would benefit the company. And again, there is a presumption that where the transaction is entered into with a connected party, that it was A, an insolvency transaction, and B, that the transaction wasn't entered into in good faith and for the purpose of the company's business. So I think that the practical point to really stress with regards to the clawback claims is that it is really important for directors so that they can avail themselves of the statutory defences if they are pursued by liquidators in respect of certain transactions. It is essential that directors take advice if they are considering entering into a transaction when the company is in doubtful solvency, and to hold regular, well-documented meetings in which their reasoning is clearly recorded, so that they will be able to make good their defences if they are pursued.
Mungo, I so not to derail you, but I wonder if now might be a time to jump in and ask at what point directors should possibly be alive to the fact that their duties may be owed to directors rather than the shareholders.
Andrew, do you mean to creditors rather than shareholders?
Sorry, creditors rather than shareholders.
Yeah, that's a very, very, very good point, Andrew. It's tied up with the second category of claims that might be brought against directors, and those are claims for breach of duties, misfeasance, insolvent trading, etc. And it really is relevant to claims against directors for breach of duties. Broadly speaking, a director is under two categories of duty. It owes fiduciary duties, so duties to act honestly, in good faith, and in the best interests of the company, or if permitted, the company's parent company. And then the second category of duty are the duties of care, diligence, and skill. And those duties ordinarily are owed to the company. And the interest of the company means the interests of the company's shareholders as a whole. However, once a company becomes insolvent or doubtfully solvent, the director's duties shift and they are owed to the company's creditors. And the rationale for this is that where a company is insolvent or doubtfully solvent, it's the creditors that have the principal economic interests in the company. But it is very difficult in practice to pinpoint the moment when those duties shift, or to put it another way, that the moment when directors are required to take account of creditors' interests above shareholders' interests. And different courts have grappled with this issue over the years. The case law is littered with references to companies being in, quote, dangerous or precarious financial positions, or doubtfully solvent, or bordering on insolvency, the point of no return, a real or remote risk of insolvency. It seems like that some consensus has now emerged that there is what's referred to as the verge of insolvency test, which now seems to be accepted by courts in various common law jurisdictions. And the essence of the test is that directors ought, in their conduct of the company's business, to be anticipating the insolvency of the company, because when it occurs, the creditors have a greater claim to the assets of the company than the shareholders. So rather than taking advantage of hindsight, I think what this test is trying to encourage is for directors to be on the lookout for the company becoming insolvent. And it's trying to encourage a culture by which directors are constantly monitoring and taking into account the financial position of the company before they enter into transactions.
Okay, I mean, that also quite great segues into what should we do if the company is going insolvent, or the signs, as you've discussed, Mungo, are starting to appear. We've talked about signs of distress to look out for, and I'm sure the audience are far more hands-on and day-to-day see these examples happening in their day-to-day professional lives. So what steps should they take to protect themselves, just to develop what Mungo was saying? I think.
Well, and there's, I think, let me cover off two points there, and some of this is repetition, and I don't think we apologise for that. But the main thing is to be proactive. As the company, whether you're involved in its management, or its oversight or its direction, being proactive, making sure you're asking questions of the company, of the board, of the company's advisors, that you're seeking advice where it's appropriate to do so, and that you're taking an act. If before in any of those roles you've not been taking an active involvement, you need to start taking one. And in terms of that seeking advice, what do we mean? That can mean from a lawyer, or it can mean from an insolvency practitioner, or it can mean from both. You're never going to be criticised as someone who has responsibility for the management of a company in some capacity for getting advice and getting help. And indeed, it protects you from potential, or may protect you from potential liability in the future. It may also be that that advice allows for non-insolvency options to be explored and for mitigation to take place, so that there can be a rescue of the company, or indeed a wind down that takes place on a more planned and careful basis, so that whilst that company may come to the end of its natural life, it does so in an orderly way, without sort of a big nasty liquidator trying to sort of ask questions of what's been going on. And I will come back later to why we're not all nasty and horrible. But the second strand of that is around, it's worth mentioning herein, is insurance. And as a company, and as a company's principals and its advisors, directors, you need to make sure it's in place. Having insurance in place doesn't put a target on your back, but it does give you that extra protection for when things have taken place where you've not been grossly negligent or the company hasn't massively erred, but where an insolvency practitioner does come along and say, look, we're trying to swell that pot of money that's available for creditors that Mungo set out, and an obvious place for us to go is the fault of, or the perceived fault of, those providing services to the company. That could be auditors, it could be directors, it could be even legal advisors. You don't want to be on the end of one of those applications to court on that litigation without having appropriate insurance in place behind you. It's a double-edged sword, because obviously as IPs we target it and we see that that's an obvious place for recoveries, but a sensible IP is never going to take an action that they don't think is justified and appropriate. So you're much better to be insured so that you're covered for those non-deliberate slip-ups that happen. Those slip-ups themselves can be avoided by taking lots and lots of advice.
I completely agree. Being proactive is the way to go. Taking a passive approach to a company that's experiencing distress will only mean that you are potentially one of the people that contribute to that worsening. Being proactive means looking at the business, understanding what the problem is, and trying to understand how you might fix that. We've talked about the fact that insolvency doesn't always mean the end of the company, because there could be issues within the business that mean there's a portion of the business that's having a problem, but other parts of the business might still be viable. So, for example, you might identify that there's cash flow problems in the business. It might be that a customer is having distress, and the slowdown or the delay in payments from a customer is causing cash flow issues in your business. Supply chain is a very topical issue at the moment, and we're seeing that across the press, possibly in person. It's a global issue where supply chain is being effective. Therefore, delays in shipments means delays in final payments, which means cash flow issues that might affect broader business. And then financial issues in general could be underpinned by operational issues. For example, not being profitable enough because a product isn't being successful, or margins are being squeezed by increased overheads, means lack of profitability, lack of cash to pay down creditors, particularly secured creditors. So, there could be a whole myriad of issues that are affecting this business and causing this distress, but getting to the root of the problem is the critical issue to trying to fix it. And then obviously the next step is appointing suitable advisors to help, because there are lots of professional advisors out there. Directors aren't expected to have all of the answers, but they are expected to take steps to engage with people who might be able to help.
And it's probably important to note that when one thinks a company is in distress, that doesn't mean you just throw up your hand and stop at that point in time. So it's much more about taking that care, we keep reiterating. So if you're approving expenditure, you make sure you're approving it in the genuine belief that it's going to improve the position for creditors, or it's going to help stave off insolvency, and you document those decisions. Ultimately, it comes down to what would the sensible, educated man on the street be doing in that scenario with the same sort of knowledge that you have. And it may be other steps, like setting up trust accounts with respect to specific payments coming in, putting in procedures that are more like proprietary buy or return type procedures, retention of title type points, where one can allow trade to continue but not worsen the insolvency position. And that is the key thing that an insolvency practitioner will look at with respect to a company, is have steps been taken deliberately or through negligence, accidental negligence, to worsen the insolvency position, or has steps been taken in the genuine belief that they will be improving that situation.
Yeah, absolutely. In terms of day-to-day practical considerations, Mungo talked about connected and unconnected party transactions in this look-back period. That absolutely highlights the critical need for good corporate governance and documenting of decisions. We always need to do that, but in signs of insolvency situations, it's even more important. A liquidator will look at payments made during that period and question, why did you make that payment? And it's easy with hindsight to sort of question, but what makes it even more difficult for a liquidator to be able to pick apart the transactions is if you documented at the time that you paid it and you documented the reasons why you were making that payment. For example, critical supplier, and you need that to produce the goods to sell to your customers. It might be a connected party, but if you documented that at the time with the reasons, it means it's less difficult to challenge, and it just rationalizes why that payment was made at the time it was made, rather than trying to do it looking back over a period of time and scratching your head as to the reason why that was made at the time. And then that leads on to preservation of books and records as well. Financial records, especially, just elaborating on payments to creditors. If you don't have up-to-date financial records, how can you justify the decisions that you made to pay a specific creditor over and above a different one? And we understand there's a lot of balancing needing to be done at this time. It's a pressured situation, and you need to compete. You've got balancing priorities, competing resources. You might be in a situation where there's limited funds and you have to make the best decision based on the information that you've got at the time. Having accurate records and up-to-date records means that decision is further supported and you can objectively explain why that was needed at the time. And then the guys have already touched on board meetings and documenting those decisions. It's an extension of good record keeping and ensuring good corporate governance in times of distress. It links into those director responsibilities as well. You can show that your fiduciary duties are discharged, and if you're making timely and appropriate decisions in the best interests of the company, which in times of distress, in this zone of insolvency, as some people call it, you also need to be making decisions in the best interests of the creditors as well, as Andrew and Russell touched on earlier. So document your decisions is a key takeaway from me.
Then, perhaps Mungo, then from a lawyer's point of view, is what happens if the situation looks basically far more serious and an insolvency is looming? Are there perhaps more formal steps that should be taken, Mungo?
Well, I think it really depends on the particular circumstances of the company concerned. The first question to ask is, can this company be saved? Is it possible to restructure a debt, or is it inevitable that the company is going to go into a liquidation process? And really, the important thing here is to get in touch with a professional to explore what the options are. There are some mechanisms available under the jurisdiction to restructure a debt in a protective environment, protected from other creditors. But maybe the first thing to explore is whether or not there can be some sort of consensual restructuring. So communicating with creditors will be important, potentially entering into standstill agreements to prevent one creditor enforcing their rights and bringing the whole structure down. But the important thing is to get in touch with a restructuring professional to explore the various options available. If it becomes apparent that it is inevitable that the company will have to go into liquidation, there's then the issue of whether or not the company initiates that, or it sits back and waits for a creditor to initiate that. In some cases, there'll be no choice. The creditor will have aggressively initiated that process, and so. Yeah, the key thing is to figure out whether or not the company can be rescued, or whether or not it's inevitable that it will go into liquidation.
Well, I suppose that once it becomes inevitable it's going to liquidation, that's possibly when we could see Russell or Anna being appointed.
Yeah, and I think that leads on to a point that Russell made earlier about choosing the right advisors. In a time where you're facing insolvency, resources are stretched, funds may be very limited, it isn't always the best choice to choose the cheapest option. It's a very difficult decision, but the cheapest service providers and the cheapest person who's willing to do the job might not be the most experienced or the right person for the job. So it's very important that expertise and skills and background and an advisor's CV is considered, and not just the price point. But we do understand it can be a difficult decision when funds are extremely limited. It's definitely another step that the board would consider and need to discuss and agree as a collective.
I don't know if that leads into me being cheap or expensive, but there we go. Just talking from the point of view, when we are appointed, and this is an important thing for the company to understand, whether that is the court route, so a creditor has led that appointment, or whether the company itself, so the directors have effectively gone to the shareholders, or the shareholders who are in charge anyway, have said, we will pass a qualifying members resolution and put the company into an insolvency process. The liquidator's appointment is essentially the same. It's governed by the Insolvency Act in the BVI, and that liquidator has a responsibility, as Mungo said earlier, to take possession of, collecting and realise value from the assets, and then distribute those assets on effectively what we call a pari passu, a fair basis in accordance with the law, to those people that the company owes money to. So the duty very much is to the creditors and not to other parties in almost all liquidation scenarios. There are some idiosyncrasies to that, but they're not relevant today. Now, that doesn't mean, though, when that liquidator is appointed, that the duties and the obligations of those in charge of the company just drop away. There are duties to cooperate, and there are statutory obligations to cooperate, frankly. And the impact of that company being wound up doesn't impact those changes in obligations. Sorry, that was very garbled. You have a duty as a director to cooperate with a liquidator and to help explain what's going on. One of the things we often get asked is, well, fine, I'm about to be done with this company, or now that it's in liquidation, I resign, or can I resign? All I'd say is a sort of passing observation there is that it's often quite suspicious when a director jumps ship just before a company goes under or immediately after it has happened. I'd also make an observation as an insolvency practitioner that we don't really see any such thing as a nominee director. As far as I'm concerned, with my IP's hat on, anyone involved in the ongoing day-to-day management or the oversight, and I use that word oversight broadly, of a company has responsibilities with respect to it. But the role we are brought in to do is to understand that a company goes into a process because it suffered financial difficulty, and that is often not the fault of anybody. So doing the right thing, working with a liquidator to help them get through, understand what's going on and get through the issues is normally a very good sign that this is just something that has happened that no one wanted to happen in the first place.
And a question, excuse me, that often I certainly get asked is, does insolvency always mean the end of the company? I don't know if Anna, you've got any views on that?
Yeah, absolutely. I think insolvency has always had a bit of stigma attached to it. It does certainly create a little bit of fear in a lot of people, and it makes people think that it's, lots of people have been left out of pocket, or directors have done the wrong thing. There can be many reasons why a company goes into insolvency. a failed product. You know, we've talked about supply chain issues. We've talked the global pandemic. COVID's had a huge impact on lots of businesses through no fault of you know, the people who have been running those businesses. So insolvency doesn't always mean the end for a business. It doesn't always mean it's terminal. The BVI has shown that it's open to restructuring, and the BVI courts are willing to use the existing insolvency regime to assist with cross-border restructuring. We've seen the use of provisional liquidations, which is a way to use liquidations to create a moratorium, which is a freeze against creditor enforcement, as a way to give a standstill and to give the directors time to breathe and assess the future options for the business. And we've seen the BVI courts accept schemes of arrangement, which is a way to restructure cross-border groups. So for the purposes of these types of reorganizations and restructuring, where parts of the business may no longer be needed, but other parts of the business might be viable to continue, the BVI courts are open to that. But that leads to, there are other times when it is terminal and there is no future for the business. And in those situations, it should mean the end for the company. Where a director is involved and they see that there is unfortunately no light at the end of the tunnel, they should take steps to bring that company to its natural end, and they should wind up the business. And leading on from a point that Russell made about directors' duties, absolutely. In certain circumstances where, you know, there's no future, the directors should be proactive in bringing that company to an end. And regardless of when the liquidator is appointed, and the director's duties, or the director's powers cease on the appointment of a liquidator, their fiduciary duties to that company continue. And it's the responsibility of the directors to work with the liquidator for an orderly wind down of the business. So yes, it doesn't always mean it's the end, but in some circumstances, it's the right thing for it to come to an end.
Excellent.
I think.
Sorry, Russell.
I was just conscious I don't think we've said this to date, that whatever it is, whether it's an attempt to rescue a company or bring it to an orderly and natural close, one thing I don't think we've stressed is that in almost all scenarios, active communication with your stakeholders, with a company's stakeholders, is really important. It's not just about taking legal advice, it's about saying to people and being honest with them, saying, look, we've got some difficulties. And this is how the situation is unfolding, and this is what we're doing about it. When things come as a shock, that's when you get statutory demands issued at you. That's when that process is taken outside of the control of the company. And that, in general, is something that should be sought to be avoided.
Excellent. I'm conscious of time, but perhaps we've discussed a great deal on the flags and the BVI company's role internationally, but I think what the audience probably like to know is, what does this really mean for me? And when I mean me, I mean them. I don't know if any of you have any specific takeaway points that you'd like to impart upon the audience. Mungo?
Yeah, I mean, I think the key thing, certainly from a director's point of view, it is very difficult pinpointing the moment in which directors' duties will start to be owed towards creditors. In order to cover the directors' back, we've discussed at length the practical steps that directors can be taken. But the one I would really want to place emphasis on is accurate, detailed minutes recording the reasons for decisions. I have had situations where I've been advising directors who are being sued by directors for insolvent trading, breach of duties, for entering into transactions when the company was insolvent, and they've said, well, you know, of course we reached this decision. The reason why we reached this decision was because we clearly thought it was in the best interest of the company. You read the minutes, and that's not what the minutes say. And if the minutes had been specific in addressing that point, it would have put them in a much stronger position in facing the claim. So I would really emphasize accurate minute keeping.
I would certainly agree with that from my experience. Russell, Anna, any takeaway points?
Yeah, I'd second the minute keeping, of course, but also be mindful of what the duties are that you owe to the client. So it could be different depending on if you're a registered agent or a director, or other services that you might be providing, bespoke services. Be aware of what your duties are and to who. And again, document all decisions. It can't be stressed enough.
I'd agree with all of that. I'd just add that anyone involved in the oversight and management of a company, and I do very much include corporate service providers in that bucket, just needs to be vigilant. They need to make sure that they are engaging the right people to assist them, whether that's on a day-to-day basis as directors or with specific issues in terms of legal or IP's advice. And they need to, as I say, be looking at the situation, being very aware of what's going on globally, and keeping a much closer eye on the way in which the companies they have responsibility for are operating during the current global environment.
Well, I am conscious of time and everyone's busy, but I'm going to stop sharing my screen so that I can start to see any comments. I think we've come to the end of the talks from the panelists, and I thank them all. I wonder if there are any questions. I think normally I would expect to see raised hands, but when the COVID-induced Zoom calls, I think if people have any questions and put them in the chat, I can read them out. But whilst people are thinking that, I think if I start with one that's occurred to me that I would ask all three of you, is if any of you have any views on when a corporate service provider should, if at all, jump in and contact a lawyer or an IP and raise a red flag. I don't know if there's any specific point that in your experience you would recommend that that's when they do it.
If anybody want to take that, I don't mind taking that one. I think it comes down to what services are being provided and who the contract is with and what the scope of that arrangement is. You can distinguish directors a little bit from registered agents, but they still have an obligation to the company, and it depends on what the issue is. I don't think there's a situation where you should jump to contact external parties on behalf of the company, unless you're authorised to do that. Certainly, it would be a case of trying to engage with the client in the first instance, trying to get clarity on what the problem is and what the client is doing with regards to that issue. Of course, I distinguish normal trading insolvency issues from anything like regulatory breaches or money laundering suspicions, which there's obviously a regime for dealing with those separately and confidentially. But with regards to normal insolvency distress in the business, would engage with the client first. And if you were a director, for example, you could obviously engage on behalf of the company with advisors. That's not really an option for registered agents as such, but certainly consider what the ongoing relationship is going to be like with that client if they're facing insolvency. So I know it's a difficult decision to take to resign, and it would be documented, and there would be overriding factors that you would consider when you come to that conclusion. But it would be a situation, I would imagine, if you were as a director of a company, that you would want to be seeking legal advice if you're not getting any engagement with the rest of the board of directors of which you're on, or seek to speak to the shareholders.
And I know I don't have much at all to add to that, and it's more your area of expertise, but I would have thought that as a CSP, that legal advice even for them can be important, depending on the size of service provider you are. You may have in-house counsel, you may be associated with a law firm. Don't bury your heads in the sand and go and speak to someone about what it means for you as the corporate service provider. And if you're really concerned, go to external counsel. If needs be, better to protect yourself than not protect yourself. And be very aware of that fine line, isn't it, between something that's an FIA type issue, you know, a whistleblower type issue versus we're seeing some real signs of insolvency. We should at least raise our hand within the confines of the client relationship.
Yeah, absolutely.
Yeah, I certainly myself, looking back, it's very easy to see when people should have. I was thinking there was an issue, but the next question is, why did you do nothing about it? Well, again, I'm conscious of time. I'm having a look in the chat. I can't see any questions in the chat. If someone wants to very quickly raise a hand, I'll pause. But if not, it just leaves me to thank Russell, Mungo, and Anna for giving up their time today. Thank BVI Finance and RISA for hosting this and putting it together. It's the third talk in this webinar series. So I hope that those of you who have seen the first two are seeing how RISA and BVI Finance are pulling in all the issues that are pertinent to us all in the industry and in the jurisdiction. And yeah, if there are any questions afterwards, please, you have our details, our email addresses are there. Please reach out. I don't think any of us will mind answering any question by email or having a chat, or buy us a beer when you see us in Roadtown. With that in mind, thank you very much. Have a great rest of the Wednesday, and thanks very much. I'll leave it there.